Not only is this such a fundamental principle of race-based remedies, of course, being racist is unconstitutional. You're just not allowed to do that. The 14th Amendment says that. The 15th Amendment says that. But every once in a while, like in 1965, when we're wrapping up the Jim Crow era, the law decides, men decide, women decide, that they're going to allow for racism to fix past racism. But that's never intended to be permanent. That would be crazy. So they say, listen, we think racism is bad, and we're not generally going to allow it, but we're going to allow it in this limited context because we need to fix the previous racism. But it's always self-limiting. And this woman not only wasn't asked about this question of how long should this remedy be in place, she volunteered to talk about it just now. But then she doesn't understand this basic principle that, of course, any race-based remedy must be inherently limited because we can't allow racism as a matter of course for no good reason. Let's get back to her.
What decibel
Congress. And finally, this is a significant concern where Congress was very clear that it did not want to include a durational limit. Congress included a durational limit in Section 5 of the Voting Rights Act. It created a mechanism for reauthorization. It decidedly did not do that in Section 2.
The issue, as you know, is that this court cases in a variety of contexts have said that race-based remedies are permissible for a period of time, sometimes for a long period of time, decades in some cases, but that they should not be indefinite and should have an endpoint. And what exactly do you think the endpoint should be, or how would we know for the intentional use of race to create districts?
Well, Justice Kavanaugh, you raised a very important distinction, and that's between remedies and the statute. So a race-based remedy can and should and usually does have a time limit and a durational limit. Section 2 court-ordered remedies have a time limit. And so that is something that is grounded in our case law. What is not grounded in case law is the idea that an entire statute should somehow dissolve simply because race may be an element of the remedy. So for example, this case has affirmed Title VII. It has affirmed Section 1982.
By the way, I showed you all the section of the Voting Rights Act they're arguing about here is Section 2. I showed it all to you at the start of the show. It's one sentence. It says nothing about majority-minority districts. It says nothing about concentration of black voting power, particularly to the detriment of white voting power. It says nothing about any of that. That is all a fabrication of the federal courts. So a perfectly legitimate outcome from these oral arguments could be for the Supreme Court to come back and not repeal Section 2 of the Voting Rights Act. Simply say Section 2 of the Voting Rights Act does not say any of the shit you people have been doing. Section 2 of the Voting Rights Act does not justify majority-minority districts. It does not justify concentrating black political power at the cost of diluting white political power. It doesn't stand for any of that, so stop it. We're not repealing the statute. We're not finding Section 2 unconstitutional. We're finding your application of it unconstitutional.
The Family Medical Leave Act, and also Section 4E of the Voting Rights Act in Katzenbach versus Morgan, and never has it suggested that any of those statutes should dissolve in and of themselves as opposed to the remedy.
I'm sorry to interrupt. I don't think it's the statute. It's the particular application of the statute that entails the intentional, deliberate use of race to sort people into different districts. That particular aspect.
For those who may have joined late, just indulge me for a second. This is Section 2 of the Voting Rights Act of 1965 in its entirety. One sentence. No voting qualification or prerequisite to voting, meaning like no test, no quiz, or standard practice or procedure shall be imposed or applied by any state or political subdivision to deny or abridge the right of any citizen of the United States to vote on account of race or color. Where does it say a word about majority-minority districts? Where does it say a word about dilution of black voting? That's all a fabrication of the unelected black robe tyrannical inferior district trial court judges interpreting and applying the statutory language. They made it all up, my friends. They made it all up. And that's what the Supreme Court is getting at here. We're not even talking about the statute, because what you're doing is not in the statute. What you're arguing for is nowhere to be found in this statutory language.
I'm guessing the particular. Well,
as opposed to the remedy.
I'm sorry to interrupt. I don't think it's the statute. It's the particular application of the statute that entails the intentional, deliberate use of race to sort people into different districts. That particular aspect, I'm guessing, I'm asking what you think the time limit on that should be, or there really shouldn't be a time limit. I think you might be saying there shouldn't be a time limit unless Congress chooses one.
I am saying that. I'm saying there should not be a time limit, but I also think it's critical to emphasize that Section 2 does not require a race-based remedy in all circumstances.
Is that because,
can I ask, I just wanted to follow up on Justice Kavanaugh's question. What if this is an exercise of Congress's enforcement power? If we're looking at the City of Bernie test and we're saying it has to be congruent and proportional, would that affect your answer to Justice Kavanaugh's question? That if it's going
this
above
is Amy Coney Barrett now.
and beyond what the 15th Amendment requires of its own force, but Congress has actually chosen the Voting Rights Act as a remedy, does that affect the question of whether it can go on indefinitely or not, that at some point it becomes not congruent and proportional?
No, I don't think it does. First, Bernie should not apply to Section 2.
Just assuming
that it
my
does.
question is.
Sure. Assuming that it does, as you know, in Bernie, this court held up the Voting Rights Act as the paradigmatic example of congruence and proportionality. The fact that the Voting Rights Act at times may require a race-based remedy does not change the fact that Congress, with its enlarged powers as defined by Ex parte Virginia and the line of cases forward, can address conduct that is beyond what the 15th Amendment addresses. It doesn't need to simply parrot the 15th Amendment. It can address conduct that is even considered constitutional in order to ensure that race discrimination in voting does not go undetected, uncorrected, or undeterred, in the words of the Senate report supporting the 1982
I guess I
amendments.
wonder if it would be helpful, at least as I'm thinking about it, because I think this is a very important question. To understand, I think that you're saying that Section 2 is not a remedy in and of itself.
Ketanji Jackson said, understand, drink, everybody, drink. I'm having lemon tea. You guys can drink whatever you like.
At least as I'm thinking about it, because I think this is a very important question. To understand, I think that you're saying that Section 2 is not a remedy in and of itself. It is the mechanism by which the law determines whether a remedy is necessary.
That's absolutely correct.
So it's a law that is just encouraging or requiring a check-in. It's like a tool. It's like a tape measure that we're looking as to whether or not certain circumstances exist. And those circumstances that Congress is worried about is unequal access to electoral opportunity. And Section 2 tells you we have to look for those circumstances. And then the court says, yep, they exist in this situation under Section 2. And so now a remedy is required. And in our case law, we then say, okay, state, it's up to you to
Under our case law, remember, all the case law is corrupt.
Figure out what that remedy will be. And maybe that remedy involves race consciousness, maybe it doesn't, whatever. But Section 2 itself is just the measure by which we determine that a remedy is required.
Louisiana's counter argument should just be bringing up Jasmine Crockett. May it please the justices. I introduced Jasmine Crockett.
That's absolutely correct.
And so that's
Or the guy who thought Guam was going to tip over. Remember that guy? If we moved more military personnel to Guam, he was worried it might tip.
why it doesn't need a time limit, because it's not doing any work other than just pointing us to the direction of where we might need to do something.
That's right.
She's so breathless. Doesn't Jackson sound breathless? Like, I want to rewind it just a little bit. Can you hear that in her voice?
Its usage becomes
direct as maybe it doesn't, whatever, but Section 2 itself is just the measure by which we determine that a remedy is required.
That's absolutely correct.
And so that's why it doesn't need a time limit, because it's not doing any work other than just pointing us to the direction of where we might need to do something.
That's right. And its usage becomes less
like
and
a
less
dog on a hot
as
day.
We see racially polarized voting and residential segregation decreasing. The Katz amicus brief in this case shows that in the past decade, Section 2 cases have decreased by 50%.
Because the plaintiffs can't make the showing. I mean, it's a pretty significant showing to establish that unequal opportunity of electoral processes is happening in a situation.
That's correct. Jingles is an exacting test. It is data obsessive. It brings in experts and many other forms of evidence to establish a racial violation. There are many cases where the plaintiffs fail in bringing the Jingles 1 precondition or Jingles 2 or Jingles 3 before they even get to the totality.
So if we're talking about a
circumstances.
time limit, you would say maybe it's with respect to the remedy that is used to respond to the problem that we've identified under Section 2. But the Section 2 tape measure itself doesn't need a life cycle. It's just, yeah.
That's correct. I mean, the 15th Amendment is permanently enshrined in our Constitution, and Section 2 is there to effectuate that.
It's worth keeping in mind that this NAACP lawyer is winning no points by persuading Justice Ketanji, I'm not a biologist, how would I know what a woman is, Jackson? Justice Jackson is already on this woman's side.
At prohibition of race discrimination on voting and does not require a time limit.
Thank you.
With the time I have remaining, I'd like to mention that
thank God there's a time limit to some things.
There are many proposals on the table that have been presented by my colleagues on the other side, and a number of them resurrect the intent standard that this court was very clear about, and Congress was extraordinarily clear about, knowing that results is key to ensuring that we do not continue to have rampant racial discrimination in voting. And the absence.
By the way, that's why all the federal court proceedings should be televised, including this one, by the way. Of course, the Supreme Court should be televised. What's the argument for not televising it when you're live streaming the audio of it? That doesn't make any sense.
Of it, or the declining ability to show a Section 2 case is because of the success of Section 2 over the past 4 decades. And we would be reckless if we determine that Section 2 somehow is no longer needed simply because it has been so successful in rooting out racial discrimination in voting. There's also, as I mentioned at the outset, a very easy and elegant solution to this case. If SB 8 is not satisfactory, if the court believes, as the Calais panel did, that the state violated the Constitution in constructing SB 8, it should remand and use one of the many alternatives that are available that meet Section 2 and also comply with the Constitution. The liability finding in Robinson is undisturbed, and it must be remedied. If SB 8 is the inappropriate remedy, there are many other options for this court to pursue.
Thank you, counsel. Justice Thomas, anything further?
Yeah, let me pick up with where you left off, which related to the illustrative map in the Robinson case. And
this sounds like
let me
Alito.
go back once again to what we said, what the court said in Milligan. The minority group, this is the first Gingell's precondition, the minority group must be sufficiently large and geographically compact to constitute a majority in a reasonably configured district. Did the Robinson court apply that, or did the Robinson court simply say that the district in question in the illustrative map, the second majority minority district in the illustrative map
Alito,
was compact? There's a big difference between the compactness of the minority group and the compactness of a district.
All of the 7 illustrative maps that we presented to the Robinson court were geographically compact. They met every traditional redistricting criteria. They even beat the state's maps on the very criteria that the state set forth that it was pursuing in the redistricting process?
Well, that wasn't my question. My question was, did the Robinson court find that the minority group was compact as opposed to the district being compact?
Yes,
It's a very
did.
serious,
Yes, it did.
I believe it didn't, and nor did the Fifth Circuit on appeal in that. And there's a big difference, and there's a serious question about whether the Black population within the district in question in the
I'm going to rewind it to make sure we all caught this, because this is an important point.
illustrative, that wasn't.
String criteria, they each have an illustrative map.
And the second, they say that the reasonably configured district. This is the first Gingell's precondition. The minority group must be sufficiently large and
not the
geographically
district,
compact to constitute a majority in a reasonably configured district. Did the Robinson court apply that, or did the Robinson court simply say that the district in question,
so group
in the
versus
illustrative
district
map, the second majority minority district in the illustrative map was compact? There's a big difference between the compactness of the minority group and the compactness of a district.
All of the 7 illustrative maps that we presented to the Robinson court were geographically compact.
That's not what he asked you.
They met every
asking
traditional
about the
redistricting
group.
criteria. They even beat the state's maps on the very criteria that the state set forth that it was pursuing in the redistricting process.
Well, that wasn't my question. My question was, did the Robinson court find that the minority group was compact as opposed to the district being compact?
Yes,
It's a very
did.
serious,
Yes, it did.
I believe it didn't, and nor did the Fifth Circuit on appeal in that. And there's a big difference, and there's a serious question about whether the Black population within the district in question in the illustrative map was geographically compact. You have people from a rural area in the northwest part of the state, and you have people from an urban area many miles away.
So if you don't know, maybe can you envision here? Let me see if I can pull up the proposed district. See if I can get a map on this. It really is egregious. This is the map she's arguing for. Her majority minority map that's supposed to be reasonably concise, contiguous. It has in the bottom right hand corner, we're approaching New Orleans. And so it has to connect all the major cities. It has to connect New Orleans, Baton Rouge, and Shreveport, because that's where the Black populations are found. But they're completely different. This northwest corner of Louisiana is extremely rural. And of course, New Orleans is extremely urban, as is Shreveport. So these populations are not reasonably contiguous. These Black populations are in these isolated little spots here. They're not reasonably contiguous.
Combined in a district just for the purpose of getting over the 50% BVAP.
So, Justice Alito, you might be referring to SB 8 as opposed to the illustrative maps.
No, I'm referring to the illustrative map, although the same may be said about SB 8, but I'm referring to the illustrative map. Well,
That's not the way to win an argument with the Supreme Court justice, by suggesting to him that he's looking at the wrong thing. I think you're looking at the wrong thing, Your Honor. Oh, no, I'm looking at the right thing.
We don't need to pray. Combined in a district just for the purpose of getting over the 50% BVAP.
Listen.
So, Justice Alito, you might be referring to SB 8 as opposed to the illustrative maps.
No, I'm referring to the illustrative map, although the same may be said about SB 8.
Because SB 8 is the map she thinks is racist. She's arguing against it. Her illustrative map is not racist. So if you're talking, you must be talking about their racist map, Your Honor. You can't be talking about our non-racist map. He's like, no. I'm talking about your racist map.
But I'm referring to the illustrative map. Well, we don't need to argue about what was done in the case, but it's my firm recollection that what the district court did and what the Fifth Circuit did on appeal was not to apply the correct standard under Milligan. Thank you.
Justice Sotomayor?
Council, states maps joined people in districts from the far north all the way down and across the state.
That's correct.
The map that it put into effect. So the district wasn't compact, and neither were the interests necessarily compact, except that they were white voters, correct, and Republican.
Correct.
So it stays hot.
Now, you have not
Just
addressed
pour it in.
the issues of the unconstitutionality, which is what this re-argument was about. Justice Barrett mentioned congruence and proportionality. Others have suggested that our Harvard case is appropriate. One, Louisiana has said that the use of race in any way violates the Equal Protection Clause. Would you give us a couple of lines on why those, assuming, as the chief did?
So obviously, racism violates the Equal Protection Clause. Giving people certain benefits, including concentrational political power based on race, violates the Equal Protection Clause. The only rational argument can be, yeah, we know we're violating the Equal Protection Clause, but we're doing it for a really good reason. And that reason still exists.
Sure.
Others are now saying, your adversaries are saying, even if it does, we should still declare this unconstitutional. I don't know that you've addressed that.
Happy to. So SFFA is an entirely different case from the one before the court at the moment. SFFA made clear that it is still constitutional to use race to remedy specified discrimination, which is what we have in the state of Louisiana, what we showed before the Robinson court. So SFFA is in fact working more in our favor, we believe, than supporting our opponents. And there are many distinctions between this case and the SFFA case. For example, Section 2 is a decidedly remedial statute. SFFA involved the diversity rationale involving a admissions process with a university, not a statute that is derived from Congress's enforcement powers under the Reconstruction Amendments that deals with remedying discrimination. That is a very clear distinction. This court has been clear in Shaw, in SFFA, in Croson, in Fullalove, that you can use race in a limited way to remedy racial discrimination. The other factor that makes SFFA reconcilable with Milligan, which is controlling here, is that we know both decisions were issued within 3 weeks of one another. It is illogical to think that this court issued the SFFA decision and Milligan in the same term and the same month even, and somehow those cases work at cross purposes with one another. So in our view, it is very clear that the case law before this court supports the use of race as needed once there has been a showing of specified discrimination. And the Section 2 test gives the court an inference of intentional discrimination to draw upon. Congress was very intentional in crafting the results test to balance the concerns of getting at all discrimination in our electoral processes, but also being mindful of a potential allegation of racism against states and other state actors. And so Section 2 requires neither a confession nor an accusation of racism. It looks strictly at results, which this court has upheld on numerous occasions, including most recently in Milligan, but before that in Lopez, in Bernie, in City of Rome, written by Justice Marshall for this court, made very clear that results is constitutional and that the use of
Justice Marshall. Guess who replaced Justice Marshall? Does anybody know? What Supreme Court justice replaced Marshall? Clarence Thomas. And this whole argument is ridiculous. She's arguing here that, listen, Section 2 of the Voting Rights Act doesn't require that we ask about racism or that we look for racism or that we prove that the results were racist. We just have to not like the results. And the only thing that could possibly rationally justify racist behavior today would be to make up for racist behavior in the past. And here she is conceding that, no, we don't even have to show whether the result we don't like was the result of racism. We can just presume that to be the case.